Good afternoon, everyone, and good morning to those of you on the West Coast. This is Josh Lee, and on behalf of the Public Contracting Institute, I'd like to welcome you all to today's GovCon 101, covering ethics and compliance, joined by our expert instructor, Fred Gelding. Before we jump in, I do have some housekeeping announcements. Just a reminder, we will not have passwords for the GovCon 101, but please do participate in any polls that might pop up. If you're looking for a certificate, you'll complete that password survey or certificate survey under your certificate and courses account on our PCI website. If you have any questions about that, please let me know. A copy of the material can be located under that paperclip icon. It'll be under that GovCon 101 title. If you have any technical difficulties, please let me know. I want to make sure you guys have a smooth experience. With that, if you have any questions, feel free to send them through the questions panel. We will most likely address questions after these slides. But again, we do welcome any questions, so make sure you send those through. And with that, I thank you all for joining me. I'll hand it to Fred.
Thank you, and welcome everybody. I hope that you're handling the snow for those of you in snowy areas, which is probably a majority. And if you have to take time off from your shoveling, it's hopefully nice and warm where you are, inside, of course. So we're going to be going through fairly quickly today. We have an hour and a quarter to cover a lot of ground. But first, a couple of slides for introductions. Just a little bit about my background. I'm currently senior counsel at the Steptoe Law Firm. Not surprisingly, my area is government contracts, and within government contracts, compliance and OCI. But the firm itself does all aspects of government contracts work, negotiation, protests, claims, you name it. Maybe more important, I spent 21 years in electronic data systems, good part of the time managing our contracts and legal group. And a lot of the things we talk about today will be things that I encountered and experienced there. From time to time, I may bring up some examples, although time permitting, that may not happen too much. So first, that's my introduction. I won't ask each of you to introduce yourself, but let's at least get a couple of things out of the way. First, a little slide to see which team you're on. Can we do a polling question?
We sure can. I got that poll on the screen. I'll give you guys a moment.
Okay, I think we got a pretty good representation. Let's end the poll. Most of you are contractor support, which is typical for this class, but some agency. For those in the agency, I tend to talk from the standpoint of contractors, but I will try to bring in the agency side of it as I can. And this is just an agenda. You can see the subjects we're going to cover are quite broad. I won't read them all. You can. I'm talking fast because I want to make sure we can cover as much ground as we can. So let's talk a little bit about why we're having the course. As I'm sure you all know, being in the class, compliance is a critical part of doing business with the government, or if you're in the government, it's a critical part of what you do in the contracting area. So we need to understand the rules, and we need to understand the importance of following the rules. And maybe most importantly, we want to recognize when there are problems before we encounter them. When you see that pothole, you don't necessarily have to know how deep it is, how wide it is, or the best way around it, as long as you stop before you step in it. And you can consider and maybe ask people who can help you so that you can get around that pothole. What we want to really do in this class is make sure that we know where the potholes are so we don't step in them. And let's start with the government standard of conduct in the FAR. And it's pretty much the same in the FAR Revolutionary Overhaul. Government business shall be conducted in a manner above reproach, preferential treatment for none, impartiality, impeccable standard of conduct, public trust, avoid conflicts of interest, avoid even the appearance of a conflict, um, accountability, no reluctance to disclosure. Those are the things that our government folks are expected to follow, that we expect them to follow, whether we're contractors or citizens without necessarily being in the contracting shop. What about the contractor? Do you have the same obligations? Well, pretty much yes. You're part of the team. You're part of the team that's helping the government agency achieve its mission. Yes, you wear a different uniform. There's some differences about that, differences in the role. But if you're going to support the agency's mission, that includes supporting the agency's responsibility to protect the public trust, to maintain the public trust, to protect the public interest. So even though we may have different aspects, different roles, and maybe even different rules, the ultimate goals are, from a compliance standpoint, are really pretty similar. And then, as we know, we're in a heavily regulated market. It's critical that second bullet, things that are legal and acceptable in the commercial marketplace are sometimes illegal, unacceptable in the federal government marketplace or on government property. That's particularly important for those of us who have just come from the commercial world or maybe still practice business in the commercial world. Maybe we work on both commercial and government accounts. It's important to understand the difference. And sometimes I ask when I do this class in person, I ask, how many of you are involved in commercial contracting? And I'll get a few hands. And then I'll say, does that mean nobody here buys a car or maybe buys a used car or rents an apartment or buys groceries, and I go on. And the point being that, of course, we're in the commercial marketplace. That's where we live. That's our norm. That's how we grew up. It's the government business that's new and different. And for some of us who have been in the marketplace for a long time, it's not so new and different, but it's still not what our commercial life is like. And we have to recognize that difference. And so for all of that, it's important to have a compliance program, which we'll talk about at the end of this session. It's required under the FAR, but even if it weren't required, it's still an important part of making sure you stay out of trouble, you manage the risks, and frankly, if you do get in trouble, you at least can make a good showing that you did everything you could to avoid it. Good faith effort, and we'll see that as well. Here again, the critical thing is that we and our employees have to recognize the potholes before we step in them. Now, I could have this slide after every subject matter because these are the things, these bad things that happen or can happen when we have failures of compliance. So let's try to avoid any of this. It's not just the company that's at risk. Company could be suspended, debarred, lose out on responsibility determinations, even have criminal penalties and certainly fines. But note that individuals are also susceptible to the same sanctions. Individuals can be suspended and debarred from government business. In fact, when you look at the list of parties who have been suspended and debarred, there are many more individuals than companies. That doesn't mean that the government goes after the little guy and not the big guy. What it means is that if a company is suspended or debarred, the reason they are is because of something that people in that company did, usually more than one. And they will also be subject to the same sanctions. So I like to talk about the questions we should ask ourselves whenever we encounter a question of, should I do this or should they have done that? How will this look to the investigator or the prosecutor, the one who is not going to give me the benefit of the doubt, the one who's not going to assume I acted in good faith, the one I have to prove that I did not, in fact, act wrongly? How would this look in the front page of the newspaper? Would I want this on the front page of the newspaper? Would I want my mother to see it on the front page of the newspaper? That's Meg Whitman's addition to this question. And then if we've been in the government business for long enough, we develop sea legs, we develop a gut, we develop antenna. And so something, maybe we don't know why exactly, but something kind of feels wrong. And when you have that in your gut, you should trust it. So let's now turn to some of the subject areas. One of the ones that's often kind of the starting point is bribes and gratuities. And that starts with a criminal statute. If you see 18 USC, 18 USC means it's the criminal code, whatever the number is. And what does the bribery and gratuity statute say? Well, it prohibits giving or offering on one side, or from the government standpoint, requesting or receiving money or something of value. It doesn't have to be money, directly or indirectly. Can't do it through a third party, to a public official, or if it's requesting or receiving by a public official. And then because criminal statutes, criminal convictions require what we call mens rea, which is Latin for really criminal intent. The mens rea here, the criminal intent that's necessary to prove a bribery conviction, is that the giving or offering or requesting, receiving, etc., was done in order to influence an official action, quid pro quo, and we call that a bribe, or in a more vague way, because of an official action, we call that a gratuity. It's a little more vague, but really you don't want to be in a situation where you're arguing, no, Your Honor, it's not a bribe, it's just a gratuity. So maybe you don't go to jail for quite as long. That's not what you want. Now, intent is required. Therefore, the prosecutor has to prove intent. How do you know what's in the mind of man or woman? The problem is that the jury's going to expect that there's some rational explanation, some good faith explanation. So you really can find yourself in a position where you have to prove lack of intent. Notice the statute applies not just to the one who gives or offers the bribe, but also the one who requests or receives the bribe. It's a violation even if the bribe is not accepted. Even if it's turned down, it's still a violation. And there's a duty to report. We're going to come to that a few times later on today. So it's not just, well, no harm, no foul, I didn't accept it. There's a reporting duty. And just in case you're involved in state and local procurement, be aware that states and local governments have similar statutes. Sometimes they go even farther. Now, that's an important statute, of course, but what's really more relevant, more helpful, more frequently at issue, if I assume that all of us are motivated by good faith and we're not going to intentionally violate the bribery and gratuity statute, now we have to look at the executive branch regulation, 5 CFR 2635. Now that applies only to executive branch employees. It doesn't say anything to contractors. But you don't want, if you're a contractor, you don't want to get your government counterpart in trouble. You don't want to be offering or giving them something they can't accept, even though the regulation doesn't say you can't offer it. They just say they can't accept it. So what does the regulation say? Well, it says that executive branch employees can't solicit or accept things of value, again, doesn't have to be just money, from prohibited sources. And prohibited sources include anyone doing business with the agency or who wants to do business with the agency or who's employed by someone who is doing business or wants to be. In other words, that includes contractors and contractor employees. Now, the good news, it's not a criminal statute. If you violate this regulation, you don't go to jail. The bad news is, as a result, intention isn't critical to proving a violation. It's kind of a black and white thing. If you didn't intend anything bad by accepting what you weren't allowed to accept, you still violated the regulation. It's strict liability. Unintentional violations are still violations. Now, the good news about this regulation is, like many regulations, they've done a very good job of including examples with the regs. And so if you're ever in situations where you have to drill down and really understand the nuances and the exceptions, which we're going to talk about in a moment, There are a lot of very helpful examples that can really guide you. So now let's look at some of the examples of what could be considered gifts and gratuities. Um, Travel and transportation. Let's suppose you have the government visiting your site and you're going back to the airport and you want to give your contracting officer a ride. Why not? I mean, it's what we do. It's, we help each other out. But if that ride is something of value, no, you're giving them a gift they can't accept unless the contract provided for it. Food, uh, paying for government employees' meals. What about taking turns? In our social life, we sometimes say, hey, I have a standing luncheon date with so-and-so, and we take turns. And sometimes he treats and sometimes I treat, and it's kind of a way of making it seem less like a business transaction. Nothing wrong with that. But don't do it with a government employee. Don't say, I'll treat this time, you treat next time. The government auditor who's looking at it, the inspector, and ultimately the prosecutor is just going to look at one instance and say, in this instance, you violated the rule, or they violated the rule. And they're not going to worry about the fact that maybe there was an offset. Sports events can be things of value. And keep in mind that some of the really famous sports events, things like the Masters and the Super Bowl, the value of what you're offering is typically more than face value of the ticket. And that comes into play because there's an exception if the government pays their own way, but they have to pay market value, not just face value. Trade shows and conferences can be another example, and there are a lot of details surrounding that. Now, so let's talk about the good side of this. What about the exceptions, the things you can do? Well, as I started to say earlier, government employees can pay their own way. You can go to dinner with your contracting officer and each pay for your own meal. You can share a cab to the airport with your contracting officer and you're sharing the cost. That's okay. Again, has to be based on market value. Modest items of food and drink. Typically, this is you're having a business meeting and you bring in coffee and donuts. That's okay. Greeting cards, plaques, trophies is an exception. Why? Well, they may have immense value to the recipient. They are very proud of it. They put it on their wall. They frame the certificate, but they're not marketable. They're not going to have value to anyone else. And then there's an important exception for gifts worth $20 or less. So these promotional items, the pens and the coffee mugs and so on, that's something a government employee can accept. But, not necessarily a good idea. First of all, while there's a $20 threshold, there's also a $50 annual threshold. So I take my contracting officer to lunch and buy them a $15 hamburger. That's not a violation. They can accept that. What if we did it every quarter, 4 times a year? Well, now we're at $60. They've gone over the $50 limit. All right, I only do it once. What if my colleagues do the same thing? Pretty soon, we're at the $50 limit. Now, should you track that? I mean, could you have every single thing tracked? Fill out in triplicate the form and so on. Should you trust the government employee not to accept more than $50? Well, you can. I mean, they are the ones who would get in most trouble, but I don't think that's a wise idea. And then there's another aspect, depending on what we're talking about, that coffee mug sitting on the desk with your company logo. When your competitor has a meeting with a contracting officer and sees that coffee mug, what kind of impression does that leave? So it's probably wise not to push that. And in fact, some agencies will say zero tolerance. Okay, what about another exception for gifts to a personal friend or relative? If your brother works for the government, you can give him a birthday present. What about friends? Well, be careful. If the friendship predates the contract, then you may have a good argument that it's really based on friendship. But if it's friendship with, hey, the contracting officer and I, we've been working together for a couple of years, we've become good friends. Well, nothing wrong with becoming good friends, but be careful about that. And certainly from the standpoint of gifts, that's not going to count. Then there are what we call WAGs, widely attended gatherings. Under some circumstances, a government employee can accept an invitation to a WAG. It benefits the government. It exposes that employee to different views and shared information and so on. But understand this is something that the agency has to authorize. If you're the contractor and you say, hey, this should be considered a WAG, you can't make that call. And there's some limits in terms of dollars and persons and so on that are spelled out in the regs. Again, it's very helpful if you're in this situation to look at the regs and look at the details. Another thing that's very helpful is that agencies have ethics officials. Every agency has what we call a DAO, a designated agency ethics official. And their job is to provide guidance to the agency employees about these kinds of things, among others. A lot of issues, not just gifts and gratuities, and they will also provide guidance to contractors. When I was at EDS, on a number of occasions, I would call the DAO and say, "Here's what we want to do. Can we do this? Within the confines of the ethical rules?" And what I found was that the DAOs were very helpful. They didn't automatically say, "No, no, no." They said, let's see, I know what you're trying to do is meritorious. Let's see if there's an exception that it falls under. They were very helpful. So just some takeaways. There's a misconception that you shouldn't sweat the small stuff. After all, when you read about the violations, they're all big ticket items. They're thousands and thousands of dollars. Nobody's going to care about that minor thing. Well, guess what? They do. Example, I had an employee come to me to talk about how the government investigator, the IG and the FBI had unannounced come to the office to interview him about a Trisha Yearwood concert. He had gone to at Wolf Trap, and the dinner he spent beforehand, he had gone with a government customer, and they wanted to know who paid their way. That's pretty small stuff. And the reason they were asking was it turns out there was an inspector general complaint against this government employee. We never quite knew why or whether it was meritorious. And so they were following up, as they should, all the possible things that might have been violations. So don't assume just because it's small stuff, it's not going to count. Whenever there's a gift, ask yourself, what's the purpose? And again, that question, how would this look to the government investigator, the one whose job it is to find fraud, waste, and abuse, the one who's not going to take your word for it and give you the benefit of the doubt. And if you're in a situation where you need to ask the government person to pay for their meal or help pay for the taxi or whatever it is, you're not offending them, you're protecting them. You're protecting them from violating the rules where they're the ones who are the most susceptible to getting in trouble if there's a violation. Okay, now let's talk about another area, kickbacks, which are in some ways harder to deal with than bribes and gratuities, and I'll explain why. First, what's a kickback? It's, again, anything of value, doesn't have to be money. This time, it doesn't involve the government, it involves a prime and a sub. It's from the sub to the prime, or an employee of the sub to an employee of the prime, or a second-tier sub to a first-tier sub. Again, it's a criminal statute, so there's a criminal intent needed, and the criminal intent I've quoted in the slide, for the purpose of improperly obtaining or rewarding favorable treatment. That's not well defined in the law, but you can really think of it, rule of thumb is it being done on the merits? Are you giving somebody the subcontract because they are the lowest price or the best value? Or are you doing it for some other reason? When you choose your basketball team, do you choose the best player, or do you choose your cousin who has never played basketball or volleyball in their life? That would be favorable treatment, and that would be improper. Now, kickbacks are illegal, and offers of kickbacks, either an offer to make one or a request for a kickback, are also illegal, and they also have to be disclosed. So that's part of why kickback rules are hard to manage. One aspect is that the parties aren't so clear. When you talk about bribes to the government employee, you know who's a government employee. They're wearing that government uniform, that blue badge, whatever. If you're dealing with primes and subs, you may be dealing with a situation where you have you're selling them both on commercial and government business. So on commercial business, you don't have the same kickback rule, but on government business you do. And so which uniform are they wearing on a given time? Um, if there is a violation, question number one is going to be about the violation. Question number two is going to be, okay, contractor, what procedures do you have in place to identify and prevent kickbacks? That's part of what the FAR kickback provision actually does provide. And then there's a reporting requirement, as I mentioned. And so the failure to report a possible kickback would itself be a violation. And I can tell you, having had to do this a few times, fortunately only a few, at EDS, it's a scary proposition to go to the government and say, there may have been a kickback here, because at that point, the government's going to jump in and say, okay, we'd like to send our investigators and confiscate your computers and so on. So you want to have the trust of the government. The famous time when I had to do it, I went to the government and said, we think this may have been a kickback. We're investigating. We would ask you to wait till we finish the investigation. We'll turn over the results, and then you'll do what you need to do. And they agreed, because we had a good reputation with them for integrity. And at the end of the day, when we investigated and found that it was kind of improper but not a kickback, they accepted that. And it wasn't because of my silver-tongued oratory, although I think I did a good job. I think it was because they trusted the company. The reputation is critical. So lessons from kickback. Again, why am I offering? Why am I accepting this gift? And how would it look? The same questions we ask for bribery. Sometimes there's a misconception. Things like, well, everybody's doing this. Well, got a problem with that. First of all, that doesn't immunize you. When you're stopped for speeding and you tell the cop, hey, everybody else was going that fast, that's not going to get you out of the ticket. And my experience, when I've had people come to me and say, well, why can't we do it? Everybody else does it. Typically, when we drill down, it turns out everybody else isn't doing it. Maybe there's some different contract provisions that allow it. There may be facts that we don't know. And as I mentioned earlier, in any case, it doesn't protect us even if everybody's doing it. All right, let's talk about a third thing, kind of briefly. The government has a rule against contingent fees. Those are fees paid as a reward for getting the business, a fee paid on contingency of getting the contract. Government, the premise is that if people are paid on that basis, they're going to cut corners to get the contract. Now, this only applies to third parties. So those of you who are sales and marketing, don't worry, your commissions are safe. There are not illegal contingent fees, even though they may be contingent on winning the contract. There's also an exception for bona fide, what we call bona fide selling agencies. That's if a company uses another company to do its sales and marketing, not, hey, I know this guy because he can get my foot in the door with the colonel, but rather this is a company that in fact engages in sales and marketing. And since we don't have a sales force in this area, we're going to use them. And this is a big difference from the commercial marketplace where finder's fees are common and shared kickbacks or shared contingent fees are frequent. And they may or may not be considered ethical, but they're frequent and they're not illegal. In the government, they are illegal. All right, those are what I call the no-nos. Now let's talk about some areas where there are some important rules to follow, but it's not enough to just say stay away from it. You'll see what I mean as I go through it. Procurement Integrity Act. This has two parts. The part I want to talk about first is the part dealing with the disclosure of government information. And it says that during a procurement, government officials can't disclose and contractors can't obtain kinds of information, specifically what we call contractor bid and proposal information and source selection information. I'll define those in a moment. And that can be written or verbal. The purpose is, of course, to make the procurement fair, a level playing field. Everybody has the same information. Note the footnote. We will talk about post-employment rules that are also included in the Procurement Integrity Act. We'll talk about that later. So what are those two kinds of information? Well, contractor bid and proposal information is basically what your competitors submit to the government. And it can be proposals, technical information, etc. It usually would be marked proprietary, but even if it's not marked proprietary, it still would be a violation for it to be disclosed. Good rule of thumb is, if this were our information, would we want our competitors to see it? If the answer is yes, guess what? You can presume they don't want you to see it. And then source selection information is information that is related to the procurement. It's generated by the agency, not something from your competitors. It hasn't been made public, and it would help a competitor if the one competitor knew it at the expense of others. Again, it doesn't have to be marked that way for it to apply. And it applies even if you get it indirectly through a third party. So you can see some examples there: bid prices, competitive range determination, ranking, evaluations. What about evaluation plans? Isn't Section M of a procurement an evaluation plan? Doesn't Section M tell you what's more important and less important in the evaluation? Yes, and that's disclosed to everybody, so that's okay. But sometimes an agency will have some additional guidance to the evaluators that's not made public. That would be source selection information. So I have developed what I call the drill. It's not a trademark term. You're free to use it. If somebody in your company gets information, hears information that they think might be verboten, might be source selection or contractor bid and proposal information, they need to stop the conversation. If it's verbal, if it's written, they need to stop the further spread of the information, secure all copies, limit further exposure, report it. And typically, part of the initial step will be to go back to the source of the information and ask, is this information we should have? Sometimes it's obviously, it's obviously not information you should have, but sometimes it's not clear. And so you ask, and if the answer is yes, you're free to have it, okay, good, document that. And if it's no, and they tell you destroy the information, delete it from your email, whatever, then follow that direction. Companies that have not followed the direction have done so to their detriment. And again, you want to be careful. If in doubt, ask. When I was at EDS, this was the most frequent type of compliance issue that would arise. And at least half the time when the question was asked, it turned out it was information we were allowed to have, something that was given out publicly one way or the other. But we were better off asking and clearing it than failing to ask and then finding there was a violation. Okay, let's talk now. Now, the reason I call that not a no-no is that if you're talking about procurement integrity, the easiest way to avoid violating Procurement Integrity Act is never get any information from the government about the procurement. Well, that's kind of silly. You need to get information from the government that you're allowed to get so you can compete effectively. So what you need to do there is you don't have to, unlike bribes and gratuities, where the advice is run down the center of the field, don't go near the sidelines, don't be in a position where somebody can even question whether it's a bribe or gratuity or a kickback. In the case of procurement integrity, know where the sideline is, stay in bounds, but you can use the whole field. And that's going to be true for organizational conflicts too. So what's an OCI? An OCI is basically saying that because of your other business, either you can't be impartial, You can't render impartial assistance or advice to the government. This is the definition in the FAR. Or your objectivity might be impaired. And that's kind of two sides of the same coin. Or you might have an unfair competitive advantage, which is a separate issue. Okay? So you have two concerns, really, a level playing field and whether the government can get impartial, objective advice. And then within those, there are three different types of OCIs, and it's critically important to understand what those types are, because all OCI analysis really depends on which type or types we're dealing with. So the first one is unequal access to information. That's where a company, contractor, as part of its performance, gets information about the upcoming competitive solicitation that gives it an advantage. This is information that's not public, but they get to see it because they're performing a contract and they have access to this information. Now, there's a funny line here because an incumbent will often have knowledge of the contract and the upcoming follow-on just by virtue of being the incumbent. They'll know better what the peak load areas are, the peak times for the help desk. They'll know better what some of the agency's hot buttons are and maybe who's really making the decisions, which might not be the same as the org chart shows. A lot of things just from the experience of performing the contract might give them information their competitors don't have. That's called the natural advantage of incumbency, and not a violation doesn't create an OCI. Where it's an OCI is if they, in addition to that, they get information about the upcoming procurement that goes beyond what they themselves are doing. There are different definitions of that, unique insight into the bidding or evaluation process. There are some other attempts to try to define the line. It's really not a bright line, it's a blurry line, but that's the difference. Now, if a contractor has information that would help in a future procurement, it will be presumed they will use it, okay? Somebody challenging that contractor or an award to that contractor on OCI grounds doesn't have to prove this is how they use the information in their proposal. It's presumed they would have used it. And by the way, another area where this comes up is where a contractor potentially gets this inside information, not by performing the contract, but by hiring somebody from the government agency who had this insight into either the future procurement or maybe the competitors' rates, things like that. Now, how do you mitigate? How do you deal with this kind of OCI? Usually a firewall. If people in the company get information that would help them, but if there's a firewall between them and the folks on the proposal team who might be able to use it, well, then the proposal team doesn't have an unfair competitive advantage. The other way that can be addressed is if the agency is willing to make that same information available to everybody in a timely way, so the first company doesn't have an unfair advantage. Now, notice this type of OCI is addressing the level playing field. It's not addressing whether the government's getting objective information, just addressing whether it's a fair procurement. Okay, impaired objectivity is kind of the opposite. That happens when a contractor has the ability to give advice that could help itself. Maybe it's doing product evaluations and another division in the company makes those products, or it's talking about regulating power plants and another part of the contractor owns and operates some power plants. Clearly, they're wearing two hats. They would be hard pressed to be objective in the advice they give, and again, it would be presumed that they would not be objective. So somebody challenging that OCI doesn't have to say, look at the advice they gave and look at how it helped them. They just have to show they're in a position where they could. And here, we're not talking about level playing field anymore. Now we're talking about the government getting objective advice. How do you address that kind of OCI? Typically with a workload change. You take some workload out of the contract, you have the company do it the agency do it in-house or under another contract. Or there's something called a firewalled subcontractor. If a subcontractor has a conflict, but if you exclude them from performance, so it's done by the rest of the team, that's okay, as long as the rest of the team is capable of doing it. You can even firewall the prime, but that's much harder, much more cumbersome. And then there's biased ground rules, which in some ways are the hardest one to deal with. That's where a company gets to set the ground rules in some way about a procurement. Maybe they help write the specifications or the evaluation criteria, and that will both give them an unfair advantage potentially, and also um, they might skew it in a way that's not in the government's best interest. This really can't be mitigated. Once it happens, no choice but to exclude that company from participating in the procurement. Now, I sometimes get questions, well, my job is to help, work with the contracting officer, try to shape the deal before the procurement goes out. Is that a problem? Not if everybody else has the same opportunity. You might be more effective. You might be spend more time doing it, be more persuasive. But as long as your competitors have the same chance, that's not a bias ground rules conflict. All right, so what do we do about conflicts? What are the lessons? Well, we try to recognize them early on. We try to communicate both between the government and the contractor, and also within the contractor. Sometimes one division of a company might be doing something which would create a conflict for another division. You have to be able to know what each other is doing. Sometimes you have to choose. Do I want this contract to maybe develop the plans for a big project? But if I develop the plans, I won't be able to compete for building that project, which will be many more dollars. So do I want to go for the bird in the hand, or do I wait and hope that I'll get the two birds in the bush? It's a choice, and there's no right or wrong here as long as you make that choice with your eyes open. As long as you're aware that by going for the first contract, you are going to be precluded from the second. And I sometimes have a soccer slide. I think I probably do here. I do, yeah. Picture a soccer team. The idea being that the frontline defense, and that's for both government and contractor, is not just to have the one person be an expert in OCI rules, but to have everybody in the company who is either customer facing or contractor facing be aware of things that could create an OCI. That meeting where you're talking about the contract and you morph into talking about the future procurement and the follow-on without realizing that there are contractor employees at the meeting. Things like that you have to be sensitive to. All right, now let's talk about post-employment of government officials, hiring from the government. We have a number of revolving door statutes. Some of them come from the Procurement Integrity Act that I mentioned earlier, and they both regulate the hiring, the recruiting, and also what can be done after somebody's hired. So let's talk about some of the details. One procurement integrity rule is that a government employee who is personally and substantially involved in a procurement can't discuss employment with any of the companies that might be participating in that procurement. If they want to, they have to step off the procurement. They have to step off the procurement team. Or they have to reject possible employment and not just say, we'll talk about it later after the award is made, but hell no. And you got to be careful because casual conversations can count as employment. It's not just when you're finally sitting down with the proposed offering letter and negotiating the terms. It's also that casual that backyard over the fence to your neighbor saying, look, I'm approaching 20 years. I'm kind of thinking of moving into the private sector. Your company, do they have any interesting openings that might use my talents? That could be considered employment discussion. course, government employee can't also, independent of the procurement, can't work on any matter that might affect the interests of a prospective employer. Again, this is an area where the DAO, the Designated Agency Ethics Officer, can really help, because the government employee can and should get advice from the DAO as to who they can talk to and who they can't. Now, also part of procurement integrity, there's a prohibition on hiring, not just talking employment, but hiring a government person who has been working in a high-level position on a $10 million or more contract. You can see the list of some of the people. And that says that for a year after they're in that role, they can't be paid by the contractor, which usually means if you're not being paid, you don't want to be hired. And then there is a criminal statute, 18 U.S.C. 207, that talks about what government employees can do after they're hired. So assuming they've been hired legally, there's no prohibition against the employment itself. There's still things they can't do after being hired. In particular, they can't go back to the agency and represent the contractor on any matter that they were involved in personally and substantially for the life of that matter. And the matter here means contract or task order. We're not talking about subject matter. And then even if they weren't personally and substantially involved, if they managed somebody who was one of their employees, then there's a 2-year restriction. And then if they're senior agency people, the restriction goes broader and may involve the entire agency and not just that contract. You also have to worry about potential conflicts of interest. I mentioned earlier that if a government person brings with them knowledge that would relate to a future procurement, that could create an OCI. Now, they can work behind the scenes. Remember, I said represent back to the agency. They can work on those contracts behind the scenes. And I'm not making that up. That's actually in the guidance that typically comes from the DAO when you ask the question. And that gets into the need to ask the question. And any government person who is looking to leave to move into the private sector would be well advised to get that DAO opinion. And if you're the contractor and thinking of hiring them, you should ask to see it. And if they don't have it, you should encourage them to get it. And in fact, if it's a senior DoD official, you're required before you hire them. If you're a major DoD contractor, you are required to get that letter. And now that letter does provide a safe harbor as to the procurement integrity limits, but it doesn't provide a safe harbor on 18 U.S.C. 207. So when you see that you're allowed to hire them, you still have to be careful about not using them to represent the company back to the government if on areas where they're not allowed to do that. Okay, let's move to cybersecurity, a hot area, obviously. We'll go through this quickly so you're aware of what the potholes are, but for details, you really would have to dive much more deeply than we have time to do. First, there's a basic FAR provision from it's now 10 years old, which has really the kind of security things that any contractor, any company should do anyway. Things like access control and passwords and so on. DoD goes further. They require both adequate security, which translates to a NIST standard, much more than the FAR standard. And they also require incident reporting within 72 hours. So when you've had some kind of a hacking incident, there's a reporting requirement. It's very detailed. It's very much formalized. It's not hard to do. I mean, it's not hard from a communication standpoint. There's a portal for it. There's actually a proposed FAR rule to update the FAR rules, make them more in line with DFARS, but bring it to an 8-hour reporting cycle, not 72. My prediction is that when they finally get a final rule out of this, and the review's been pending for quite a while, when they finally get a final rule, it'll probably be closer to the DFARS rule. It just makes sense to have to have convergence on that. Then there was a rule, an interim DFARS rule that requires contractors in the defense industrial base, if they're required to have that incident reporting and NIST standard provision, which basically means they're dealing with defense contract information or controlled unclassified information. These are big categories. Then they're required to do an internal audit as to whether they comply and basically post a score. And they're not eligible to receive contracts unless they post that score. Initially, the score was simply a threshold requirement. There was no requirement that they post a score above a certain threshold. But now it looks like there's been guidance to DoD that not with a specific threshold, but to say that the score should be taken into account in the contract award factor. I mean, a high score should get a benefit. You can see that the DOJ has been active in the anti-fraud area and specifically has a task force just with cyber fraud, which usually means either the failure to implement required safety provisions, cybersecurity provisions, or more frequently, the misstating of compliance, saying that they'd done something required and they hadn't done it. And you can see the kinds of dollars that are involved there, and you can see it's not just private sector companies. You have universities, Georgia Tech, Penn State, and subcontractors and so on, and consultants. It's getting to be more and more of something that contractors really have to take quite seriously. Then you have something called CMMC, the Cybersecurity Maturity Model, C, I forgot the last C, which is a rule. It started with a very posed rule that would say every contractor in the defense industrial base has to have a third-party assessment. Basically, we don't trust self-assessments. A lot of pushback on that. And so as a result of the pushback, you've got an updated rule as of last September, the final rule, and it basically says, all right, we still want everybody to engage in CMMC, but the level one, the contractors that are not really dealing with highly sensitive material, and that's 2/3 of the defense industrial base, they can self-certify. Level two, those who are kind of in the middle, they have more requirements. Some of them can self-certify, some of them need third party, and then level three, the most serious one, which is really just 1% of the defense industrial base, that's where you need the full Monty, so to speak, and self-certification. It's a threshold requirement. It's not supposed to be an evaluation factor. We'll see whether it becomes a protest factor. We'll see whether we have more False Claims Act prosecutions here. We could spend hours just talking about the specifics of CMMC, and if your company is involved in that, you need to take it quite seriously and you need to put in the time. Not something I can do more than just point out potholes today. Okay, doing business overseas. We have something called the Foreign Corrupt Practices Act, which is really a bribery statute, an anti-bribery statute that's similar in many ways to the federal bribery statute we talked about earlier. There's a lot of record-keeping provisions that are added to that, and it applies really to any company where there's any basis for jurisdiction. So it could be a subsidiary to a U.S. company, or it could be they trade on a U.S. Stock exchange, et cetera. The rule is the FCPA is actually stricter in some ways because there's no minimum, there's no $20 threshold. It applies not just to foreign officials, but to foreign political parties. There is an exception for what we call facilitation payments, and that reflects the fact that in some countries it is a custom to give something of minor value when somebody does a routine action. So you go for your routine driver's license, let's say, and you give the person who stamps the driver's license and approves it, a little token gift. That's a facilitation payment. But be careful. Don't try to claim that large-scale payments are facilitation payments and won't fly. Now, having said all of that, in February, the administration said, wait a minute, we're not sure we want to do FCP investigations and enforcement. We want to make sure we're protecting the presidential foreign policy initiatives and prerogatives. I won't tell you how I feel about that statement, but just to say, I wouldn't take it at face value that you can go ahead and violate FCPA with impunity on the theory that you'll never be prosecuted. We also have export control laws, and those are also quite complicated. They involve both Commerce Department regulations when it's a product that can be used for both defense and non-defense, kind of so-called dual-use products. Then you have the State Department manages the ITAR for products that just have defense capability. You've got the OFAC, the Office of Foreign Assets Control, that prohibits certain assets to certain countries. Don't try to send your material to North Korea, for example. Be aware that it includes things that go to people in the U.S. That's considered an export if you know they're going to be exporting it abroad. And there's something called a deemed export, which occurs when you are disclosing, let's say, technical data to a foreign national in the U.S., but they're a foreign national and you know they're going to be taking it outside the country. Here again, you have record keeping obligations. And so very often the violations that occur are not violations of the wrongful exporting, but wrongful failing to keep appropriate records of it. This is serious business. Mislabeling, another serious business. If you claim something is from the US and it's not, you mislabel it as to what country it's been in. As you probably know, we've got Buy America laws that basically, in order to protect American business, require a certain amount of content to be domestic in the products that are purchased, and really acts as a price preference because there's an exception for products that are not available being defined as not available within a certain price range. Then you have the Trade Agreements Act, which tend to offset some of the Buy America restrictions. If you're under trade agreements, then Buy America doesn't apply. It's a complicated business. And if you're doing a lot of export or import, in this case, import of components and products, you need to be jumping in and really knowing that in great detail. Again, I'm trying to point out the potholes. I'm not trying to point out the complicated rules for getting past those potholes. Human trafficking, another example, zero tolerance. And this involves not just the white slave trade, not just forced sex acts. It also involves things like using forced labor. If you're familiar with the song 16 Tons, you load 16 tons and what do you get? Another day older, deeper in debt. St. Peter, don't you call me because I can't go. I owe my soul to the company store. That would be an example of human trafficking. And the most important requirement here is if you do business overseas, then you are responsible for violations of human trafficking by your subcontractors, by your suppliers. In some countries, that can be an issue. And you can't just say, well, it's on them if they violate it. It's also on you. Okay, now let's turn to what I call the dark side. This is really the government's actions to enforce these laws. You've got the False Claims Act, and I say acts because there are both civil and criminal False Claims Act. Both of them involve asking for money from the government based on some false information, false or misleading information. But the major difference, both involve significant financial penalties. The major difference is the burden of proof, because to convict under the Criminal False Claims Act, you need to convict beyond a reasonable doubt, whereas the burden of proof for a Civil False Claims Act violation is preponderance of the evidence. That means 51%. A lot easier to get. That's why prosecutors and district attorneys will generally go for the Civil False Claims Act, because they're going to get that same huge fine. They don't need a criminal violation to do that, and it's much easier to convict, and therefore it's much easier to settle. You also have False Claims Act. You have the whistleblower provisions. Many False Claims Act, Civil False Claims Act cases start with a whistleblower claiming that a company has violated the act, has basically committed violations. And you can see the dollars involved. 6.8 billion recovered in fiscal year 2025, highest ever. And 80% of that came from the whistleblower cases. We call them key TAM cases. Cyber fraud, not quite the same dollar amounts, but 53 million is nothing to sneeze at. There is a case challenging the whistleblower provision as being unconstitutional, because the whistleblowers were not official government employees, and therefore arguably it violates the Appointments Clause. The district court agreed with that suit. It's now on appeal to the 11th Circuit, so stay tuned. We may have a big disruption in this area. And just to be aware that it's not just big dollars that matter, and not just dollars that get involved, not just civil penalties. Here you've got a criminal conviction, actually a settlement, a criminal settlement. You've got a Navy contracting officer's rep who was treated to meals, sporting events, not really big ticket items. In turn, he sole sourced some 8A contracts to the contractor. The CEO gets 4 years in prison. He was a recidivist. Maybe that's part of the reason. His former executive VP, though, gets an 18-month sentence. So don't get the idea that you don't go to jail for this. You can. Some examples of false claims and false statements. The one I'd like to highlight are the False Claims Act with schedule contracts. Many people have GSA and VA schedules thinking that that's a great way to get into government business. It is, but you really have to pay attention to the rules involving commercial sales practice disclosures. And if you change your catalog, if you reduce your pricing, you have to disclose that to the government. If you offer new discounts, you have to disclose that. If you don't, you can have serious sanctions. Product substitution, another area. You provide something different from what was in the contract. Maybe it's better. Maybe what was in the contract is no longer available. But unless you change the contract to reflect it, that's a product substitution. And even if the contracting officer is happy, the auditor might not be. So if you're in that situation, A, try to change the requirements in the contract. B, try to get the contracting officer to ratify after the fact if you can't do it beforehand. And C, worst case, at least when you submit your invoice, make it clear what the invoice is for, so that any dispute will be contractual but not criminal. So kind of some lessons. Basically, avoid getting in trouble. Suspension debarment is another area where you might say it's the dark side. It's not intended to be punitive, at least not specifically. It's really just intended to help the government say, look, we won't do business with contractors who are not responsible. and that means satisfactory record of integrity and business ethics. Suspension can be indictment or adequate evidence of any of those white-collar crimes that affect procurement. That can include a key TAM suit. Debarment usually requires conviction. You've also got a requirement that you disclose any credible evidence, not necessarily absolute certainty, of a violation involving, remember, things we said earlier about disclosure: fraud, conflict of interest, bribery, gratuity, kickbacks, or significant overpayments. You got that money, it's more than you were entitled to. Should you let the government know? Well, you better. What happens if you're suspended, debarred? You're really out of the government business. It's a death sentence. No new contracts, no new subcontracts, no new teaming, all of that. Can you keep the contracts you already have? Yes, but they could be in jeopardy. I could imagine a contracting officer saying, if you don't have the integrity to get new contracts, I don't want you on my contract, especially if there's been any issue about whether they're really happy with your performance. So what's the remedy? You need to have a contractor compliance program. It starts with the Code of Business Ethics and Conduct, and there's a requirement in the FAR. If you have any contracts that are $6 million or more, where the performance is more than 120 days, so it's not just a single purchase, you are bound, you're required to have this. And I would argue that even if you don't meet that threshold, you might in the future. And in any case, you're better off having this to help protect yourself from violations. If there's still violations, even if your contract is only $5 million, you still would be violating the law and get into trouble if you did so. So what are you required to do? Well, for any contractor meets that threshold, you have to have a code conduct. It has to be disclosed to your employees. You have to conduct business with the highest degree of honesty and integrity. Ask yourself how you would demonstrate that. Have an ongoing business ethics awareness program, disclosures of any violations, etc. And then if you're not a small business, if you're a large business, and you're not just doing commercial items contracting, there's a much more detailed set of requirements. It includes training. It includes a number of things that really are taken from the Department of Justice sentencing guidelines, the guidelines they use to decide what to recommend for sentencing. And that means having some ethics officer at a high level, internal reviews and internal reporting requirement, corrective action. Ask yourself, if the auditor came knocking on the door, what would you have to show that you assigned responsibility at a sufficiently high level, that you did the audits? What record keeping do you have? What record keeping do you have for internal reporting, for disciplinary action, etc.? Because if they knock on your door for training, do you keep track of the training you do? And do you have signatures from people who take the training that they understand it and will follow the rules? Then there's the disclosure requirement, which we already saw. It's another example of it, and full cooperation. Okay, so and just one other mention: if you are a grantee, you're governed by what we call the Super Circular, and guess what? The Super Circular has similar disclosure obligations. So let's kind of talk in more general terms here. Who are the violators of these rules? Well, obviously, if an employee violates the rules, they're a violator. But more importantly, let's recognize that any employees who authorize or oversee or condone or conceal violations, managers who fail to control what's going on, disregard violations, fail to prevent, fail to report, employees who retaliate against employees who report, or who falsely accuse, those are violators too. A reminder of what the penalties can be for violating. Okay, criminal prosecution all the way down to negative news coverage. So let's kind of recap a little bit about what I said, the football field analogy I gave earlier. Um, when should you run down the center of the field? When is it okay to go near the sidelines? Well, it's a risk reward kind of situation. Bribery, gratuities, kickbacks, all of those areas are areas where if you violate them, there's very little that you're going to gain, and there's a huge amount that you're risking. And you're risking, even if you think you were in bounds, if the ref calls you out of bounds and you have to rely on instant replay and an appeal, you don't want to do that. You don't want to be in that situation. You don't want to be spending a year of your life deciding that, no, you really didn't violate the gratuities rule. Just ask Mike Espy. He was accused of violating the um, illegal gratuities rule. He was brought to trial. What had he done? He had accepted football game tickets and drinks, expensive wine at a meal. He was Secretary of Agriculture at the time, and he uh, was accepting them from the grain companies who were regulated by agriculture. He was brought to trial, and he was acquitted of all 19 counts. In fact, the judge said that the case should never have even been brought. Um, well, he lost his year of his life. He lost the job. He lost the attorney's fees that he had to pay, all of that. Um, I think he would have been better off not accepting that meal, staying out, not going near the sidelines. Now, then you have some where, you could stay in the center of the field, but you wouldn't get any government business. You could never ask for any information about the procurement, and then you wouldn't have a procurement integrity issue. You could not have any other business and not have any other contracts, and then you'd never have an OCI issue. You could never hire from the government, and then you'd never have a hiring issue. But you'd also be crippling your attempts to be an effective government contractor. You don't want to do that. You should have the entire football field, but you should also stay in bounds. So when we're dealing with compliance, you want to avoid illegal practices, and you should avoid things that even look illegal. Need to know the rules, you need to avoid the problems, and maybe most important, know when and where to ask for information. The things we've covered today, some of them we've covered with a little bit of detail, some of them really just topside. But hopefully when you encounter them, when something happens that looks like a pothole, maybe you know enough to stop, look, and listen, and ask questions from those whose job it is to know what the answers are. And again, let me remind you of the questions. How will this look to the government investigator? How would this look on the front page of the newspaper? Would it feel appropriate? Does it feel appropriate in my gut? Sometimes people say integrity is doing what's right even when no one is looking. Not just the letter of the law, but the spirit of the law. We used to say at EDS, we used to say, could we do business in complete trust with someone who acts like this? The answer has to be yes. And then we have Mark Twain. Always do right. This will gratify some people and astonish the rest. And with that, we've come in on time and under budget. And I will stay on for any questions. I don't know if there have been any, but if there are any, I will be glad to try to answer and respond.
Thanks, Brad. We did have a couple questions come in. First question from Lanny. Sorry, I'm not sure exactly what Lanny is referring to, but she asked, how does this apply to relationships between primes and subcontractors?
All right, how does it apply with relationships between primes and subs? Well, if you're talking, I'm not sure which subject area you're talking about, but the one that's most important would be kickback rules. Those we talked earlier, and that's when a sub is offering something to the prime, offering something of value to the prime in return for favorable treatment or in order to induce favorable treatment. I'm not sure what other relationships we're talking about. If the questioner wants to maybe follow up with a little more guidance about what area they're talking about, I'd be glad to try to address it.
I'll give Lanny a moment. Or, sorry, they did add, can we as a prime have an informal friendship with a sub? Go out for coffee? Is it acceptable after the program is over?
Can you have an informal relationship with a sub after the program is over? I think the answer would be yes. Once the program is over, then at least as to that program, there's no possible violation. Now, if you have I'm not sure what kind of relationship you're talking about, but of course, if you have a relationship with the subprime and sub or individuals in that, that could be an issue in future procurements. So, again, this is kind of a fact specific kind of thing. And I can't be giving, I'm not, just to make it clear, I'm talking about the rules and how they apply, but I'm not trying to give specific advice, legal advice in a particular context without knowing a lot more facts and details. So please understand this is just kind of a topside, general what the rules would say.
Thanks, Fred. We have another question from Tracy. Actually, I
Okay.
think that's a comment. I'm going to go to the next question. What is one piece of advice for someone new in the contract discipline?
Advice for somebody new in the contract discipline?
Yes,
Is that the question?
that's the question.
Okay. Well, my advice would be to learn what you can from your peers from other classes like this one. If you're in the compliance area, there's a lot more to go into. In fact, we do a full day compliance class. We do a full day class in how to have an effective compliance program. Those and other programs would be immensely valuable. And maybe most important, try to learn from mistakes and specifically from mistakes by others. Um, we always want to learn from our own mistakes. And yes, we're always going to make mistakes. But when you can try to be observant enough and insightful enough to learn from the mistakes of others, then you get the win-win situation. You didn't make your own and you learned. So I hope that's maybe good guidance.
Thanks, Fred. Tracy states, a couple of years ago, prior to a contract being awarded, the government called me to state that our competitor, a very large, very well-known company, had deliberately retrieved government information describing the criteria met and unmet by both companies, us and them, in regards to this RFP. It seems to me this company violated procurement integrity and should have been automatically removed from the solicitation. My company did win, but the government did not preclude this company from continuing with the solicitation. Please provide your take on this situation.
All right. I understand what you're saying, that there was a major company that won a contract even though they'd gotten inside information, non-public information in advance. And what do I think of that? Well, if those are the facts, I think that there was a violation. What I would want to know, I guess, is whether anybody flagged it at the time, either a competitor or anybody in the government, as being a violation, and if so, how it was addressed, if it was addressed. I would hope that if those were the facts, and if there was a complaint made, that it would be investigated fully and there would be some kind of remediation, which could be excluding that company from receiving the contract, or it could be an attempt to level the playing field by making sure everybody else got the same information and therefore that company didn't have an unfair advantage. But if no complaint was made and nobody recognized it, well, obviously somebody did because you're raising the question, but if nobody put it before the appropriate government authorities, then I'm not, it may simply be a violation that happened that never got corrected. I don't know that there's too much to do after the fact. Maybe there's a remedy even after they win the award and perform the contract, but that would have to be, I guess, on some kind of a False Claims Act allegation. I guess that's about all I can say there.
Thanks, Fred. We have one more question. Lenny asked, is it a violation if a business development manager recommends the company of his or her spouse to be a teaming partner on a proposal?
Okay, if I understand the question, it's that the business manager in a company has some relationship with another company that, and the question is to do business with the other company. And my answer would be that's really more a matter of internal conflict of interest within the company, not so much a government conflict of interest issue. And typically, with most companies, the response would be that if let's suppose, let me give you a concrete kind of example. Let's suppose that the business manager's spouse is the CEO of a company that is a potential supplier, a potential teaming partner. My answer, if I were the ethical advisor, I would say that the spouse's company should not be prohibited from doing business with the company, but the ones making the decision to use the spouse's company should not be the spouse. In other words, the business manager should be precluded, should not be involved in the decision about who should be the teaming partner. But if that spouse's company happens to be the best potential teaming partner, they have the best products or the best costs or whatever, it still may be in the company's interest to use them as a teaming partner. Just the decision should be made by somebody who doesn't have that family relationship. And just to give you an example of that, when I was at EDS, my wife was an attorney at a law firm, and one of my people came to me and said, the business unit, wants to use, or we, want to get advice and use that particular law firm to help us on a state procurement in a different state. That firm has their headquarters in that state. We'd like to use them, but we want, but you have that relationship. Your spouse, your wife is at that firm, and what I said was, keep me out of the decision. If they are the best value for using them, you're allowed to use them. It happened that my wife was a senior counsel there. She wasn't going to receive any benefit from any business brought in. She wasn't going to be able to influence any business brought in. Nonetheless, just as an appearance matter, I said, keep me out of it. And that would be the kind of thing I would say in the situation you just described. Any other questions?
I think that wraps us up for today. If any of you all have any more questions, feel free to send them through. We're more than happy to follow up. As always, we'd love to know how we did today. All feedback is greatly appreciated. I do have that rating pull up. Make sure you guys send that your response. We are more than happy to improve. So let us know where we can. There will be a survey that pops up as you close out as well. If you're seeking a certificate, make sure you log into your certificate and courses and complete that survey. You will also receive a certificate of completion via email tomorrow, as well as a recording. So with that, I wish everyone a wonderful afternoon. Thank you so much for joining, and make sure you check out the PCI website for our upcoming trainings. Thanks so much, Fred.
Okay, thank you. Thank you all, and happy snow.